Right, a very good morning to you, ladies and gentlemen. Karibu sana. This is Morning Cafe. How are you doing this particular morning? I'm usually standing in Ringita, and we're going to be discussing matters law. Now, back in 2021, the Law of Succession Amendment Bill was assented into law by former President Uhuru Kenyatta. And this particular bill was introduced by Homa Bay Town Member of Parliament Peter Kaluma, and among others, it sought to streamline the whole succession matters, limit the dependents entitled to inherit property, as well as now to only the spouse and the children of the deceased, and will be keenly analyzing all this. But then particularly, even for this particular bill, for the whole can we stay kind of relationships. Yes, mnajijua hapa nje, the kind of cohabiting. Unasema kuja na vitu zako, and then you live together for a number of years. So, is this particular can we stay kind of a relationship, even a marriage? And then when it comes to particularly for inheritance, what happens there? We have a legal expert who's going to be helping us understand all this. Job Musembi is an advocate of the High Court. Karibu sana.
Thank you so much.
Thank you for making time.
Asante.
Even as you also give us your introduction of who you are, even away from the corridors of justice, help us understand what can we stay under the lens of the courts really means.
Yes. Can we stay the situation where parties agree to live together, and we'll assume for the purposes of this show a man and a woman, because in other places can we stay could be between people of the same sex.
Yeah.
But in this case, a man and a woman agree to live together without going through the rituals of marriage,
okay,
as understood by the law, or as provided for by the law. Can we stay in the law has had very many names given to it, especially by courts. In England, where we derive our law called common law, there has been a presumption of marriage arising out of long cohabitation. Presumption means that the court is ready to accept that parties were married if they can prove that they lived for so long.
What's for so long?
That is not defined.
Okay.
It is just long cohabitation. That's the word it's used. It varies from case to case. The Supreme Court has had an opportunity, the Supreme Court in Kenya has had an opportunity to define or delve into what is cohabitation in a decision that came out in 2023. Last year, January. Yeah. Yes, and it's a very interesting case where the Supreme Court said that presumption of marriage arising from long cohabitation is an exception. It is not the general rule. And the Supreme Court was also very clear that parties should be allowed to live together without forcing marriage upon them. In other words, parties may agree to live together when both of them know we do not intend to be considered as husband and wife. So why should the law then come and consider them husband and wife?
The Supreme Court also said that this is not can we stay is not marriage, no matter the years spent together. And I think what you're trying at is the presumption of marriage. And even wherever you're watching us from, ongea na sisi, because there's so many Kenyans out here who are in this whole mix. 0795 045 864 is the number to call us live. When you're calling us live, tell us your name, where you're calling us from, and tafadhali have your TV or have your devices off so that tunapatana vizuri. You can also text us on WhatsApp 0793 267 279. Hiyo ni WhatsApp 22047 is our SMS number. Question of the day for you. Do you think let me just get that right here. Do you think partners in a can we stay relationship should grant each other inheritance? Ongea na sisi. So for this ruling here January, so that we also try and understand it, because now this came even after that assenting into law, the ile bill ya Kaluma.
Peter Kaluma's bill.
Yes, Peter Kaluma's bill.
Yes.
So to understand this presumption of marriage as you're trying to break it down. So what does now the Supreme Court means when it says it's not really marriage at the end of the day? So when you in front of the courts as well, who falls and what does it describe as a marriage?
So marriage in Kenya is governed by the Marriage Act, Cap 105. And the Marriage Act has provided, to the best of my knowledge, around 3 instances. One is marriage that is contracted in a religious ceremony. Religious ceremony being Hindu, Christian, or Islam. And in each of these religions, the religions prescribe what a marriage is. In Islam, you can marry up to 4 wives. In Christianity, you can only marry 1 wife.
Right.
There's actually someone who has gone to court challenging the requirement that why are Christians being forced to marry only 1 wife? Polygamy should be allowed in Christianity. We'll see what the courts will determine, and hopefully Parliament may take it up, because there are Christian denominations such as the Church of the Latter-day Saints that actually believe in polygamy. So Parliament may want to change that. Apart from religious ceremonies, there's marriage that is contracted under the state, or what we call a civil marriage, or what is popularly or commonly referred by people as getting married kwa AG. That is a civil marriage. And then lastly, it's marriage that is contracted in a customary union, customary through our African customary marriages.
Okay.
Yes.
So now the fact that you've broken them down.
Yes.
And now actually for the last one there, the customary bit.
Yes.
So last year, High Court Justice Helen Rafaela Namisi found that a man could not prove his marriage to a woman he had been cohabiting with for 22 years and had 3 children with. So context, ladies and gentlemen, is this man left for the United States in 2020 and did not return. And the union was under the Luo customary marriage. And the court tells him that you can't really prove that you were with this woman for 22 years. So first off, help us understand, how do you prove even that you're married to someone, or the fact that you've been living with someone, then you're married to this person? And then now for the meat of our conversation on the inheritance. For this conversation, how then, if for 22 years, let's assume that this gentleman had already started, signing the will and the whole inheritance for the 3 children, for the wife, for example, how does this go?
Yes. So for you to prove customary marriage, you must prove that there was a ceremony, and this depends on tribe to tribe basis. In Kenya, different tribes will have different rituals. So were the rituals followed? For example, if there is a goat that needs to be slaughtered, if the elders need to sit down, if you need to bring traditional brew for the elders to take, so you need to prove that. How do you prove that? Mostly, customary marriages mostly are not documented as such. So
it just stops there on the rituals. Yes. It doesn't. There's no putting pen to paper.
You don't have to.
Okay.
As long as you can have a witness, someone who witnessed the rituals.
Right.
Most of the time, we go with our uncles, we go with our brothers. You bring them to court, and they can prove that, this ritual took place. And if you can get more than one, the better. You've proven customary marriage.
Right.
However, I have seen cases which is in the modern world today, after the rituals, especially when there's a bride price being negotiated, I've seen it being put down in writing these days, and people sign that we agreed on the bride price of 50 cows. You've brought 3 cows. You'll pay the rest as you can take our daughter and pay the rest as you live with them. Okay. And customary marriage, you just need to prove that a token of the bride price was paid. You don't have to prove that the entire bride price was paid. Right. So customary marriage, you just need to prove the rituals.
So tying that now with the inheritance.
Yes.
For example, using this case of this gentleman who for 22 years lived with this woman, and they have 3 children. And in this 22 years, conversations about inheritance start cropping up, which is very typical in any, particularly an African family, where conversations such as hena, hypothetically ukitoka ama, hii shamba tulinunua na wewe itaenda wapi, property conversations start to come up, and they trickle down to who will inherit this. So for 22 years after, for such a scenario that you're telling us, for the customary marriage, for example, how do you deal with this?
So first of all, inheritance only occurs after death.
Okay.
So before someone dies, you don't have a right to inherit their property. Anyway, the Supreme Court, again, I'll go back to the Supreme Court's decision, has said that for there to be a presumption of marriage arising out of living together for long, first, the parties must have had the intention to get married. So if you are living together and you keep telling people, marriage is just a paper, you don't have to be married to someone to love them, clearly you don't have an intention to get married. And so when things go south, don't come to claim, no, we were married because we were living together for long. So the Supreme Court now is acknowledging that people can actually live together for even 50 years when they have no intention to be bound together by marriage.
But this bit of intention, yes. Because, and just for the context of the viewer, reading it in a part of it, says where such a situation is evident, talk about the situation for the customary in the ruling, and there is no intention whatsoever of contracting a marriage, presumption of marriage must never be made where this intention does not exist.
Yes.
So in this ruling, for the intention bit, wouldn't it sound as if it's for both parties who agree that, yes, there's no intention, but what if one of the parties actually wanted, I'm really intending that where minimum for 10 years, I'd want to have a whole marriage, but the other party does not want to. How do the courts rule on this?
Actually, in the same decision, the Supreme Court held, I was trying to look for it, but the Supreme Court held that there must be consent.
Okay.
So that the intention should be both way.
Okay.
So if someone comes to stay in my house, she has the intention to be married to me, but I don't have the intention. As long as it's not double consent, there's no intention, and marriage cannot be presumed. I think you had asked about now what happens to property.
Yes. So in the unfortunate case of, now in our case here, this gentleman passes away. So what happens in such a case where the court already has ruled that there was no marriage here? You guys are cohabiting for 22 years, but there was no marriage. So in the unfortunate case of death, what happens?
So under the Succession Act, the people entitled to inheriting property are one, the spouse, so it can be a husband or a wife, and the children. Those are given the first priority. Spouse, the children. And then the third category is usually dependents, meaning you're neither a child of the deceased or their spouse, but they were maintaining you, they were sending you contribution, they were helping you, and so that's the third category.
Right. And even as you continue, Bernard Director, we also have the GFX of the graphics of that as well. For the benefit of the viewer, you can also help us as you continue. Just take a look at the Law of Succession Act. Yes, you may continue.
Yes, so you must be a dependent. You must prove that you are a dependent, and however, largely it's the spouse and the children who benefit from the. So meaning, if you're not a spouse and you are living together for a long time, and there's no proof of a customary marriage in terms of there's no proof that the rituals were followed, and you had no intention to be married, and which the Supreme Court is now saying that you guys let's be keen not to impose marriage on parties who do not want to be deemed married. Let it be an exception. Let it be used sparingly, this presumption of marriage. Now, in that case, a spouse, unfortunately, will not be entitled to inherit any property. However, if they had bought property together, now this is the saving grace and which the Supreme Court decision says that if you've bought property together, and especially in cases where you've not registered it together. You see, if you've bought property together and registered it together, there's saving grace. You have some interest or some share known in law. But where mostly it was registered in one spouse's name, maybe in the husband's name, or in the wife's name. In that case, the Supreme Court is saying there's something called a constructive trust, meaning the law is now ready to assume that your share was being held by that person in trust for you. So that if you buy 10 acres, for example, you just need to prove, though it was a come we stay, you just need to prove that you made some contribution towards acquisition of the property. If you can get bank statements showing that you transferred money to this guy which he used to buy the land, or if you can actually show that there are receipts in which you're the one who paid it, and the property was registered in that guy's name, in the spouse's name, and you are not there, the law is now willing to take it that person was registered in trust for you, meaning that your share is still there.
But you have to give evidence of you guys stay together a certain amount of time?
Not only staying together, but you must give evidence that you made some contribution towards acquiring the property.
Right.
So that Supreme Court case that came out last year, the Supreme Court actually held there was no marriage, but proceeded to hold that in this case it was an interesting case where it is a man who was claiming that the property held by the woman, he had a share in it and that they were married. The Supreme Court said, no, you guys are not married, but the lady was holding the property in trust for you.
Wakili, you've seen this a number of times, and mostly when public figures, the passing of a public figure, and it's during that burial ceremony. And a lady, in most circumstances, is also in attendance and is with a child. And this lady claims that, you know what, guys, for the last decade, we have been cohabiting, in a sense, with this gentleman as well. Help us understand how, in matters inheritance, for this other lady, as well as even for the children, how it happens if the deceased also has a wife. Because for the law of succession, as you're enumerating, it's clear for the spouse, for the children, it's catered for. But then now for this other one, not really. So what happens to this other lady and child if there's also a wife involved? So if someone had a mistress, that's the word. Yes.
Let's call them a mistress.
Yes.
Historically, in English law, children born out of marriage could not inherit. They were called illegitimate children and other bad names. They could not inherit property. But currently, under our Constitution first, and also under the Law of Succession Act, a child is a child, whether born in marriage or born out of marriage. So those children will most of the time, not most of the time, will certainly inherit property, have a right to inherit property, and will have equal right to these children who are deemed as legitimate children. However, the mistress is in a tricky situation as to whether she is entitled to inherit property. Why? It depends on whether there was a customary marriage. There are instances where a man, when he's young, he contracts a Christian marriage. And then when he becomes wealthy, he realizes he needs a second wife, but he contracted a Christian marriage. So he cannot contract he cannot marry a second wife. So the only thing that is left for him to do is either divorce the first wife and have the right now to have more than one wife through customary marriage, or in some instances they will tell a woman, you know what I will do? I will pay dowry for you, and just consider that good enough. We are married. the law in Kenya will actually deem that a wife. Yes.
Okay.
If there was a customary marriage.
Right.
Without a customary marriage, you're just a mistress. You will not be entitled to inherit property. Maybe the children, it's only your children that may get the property. Yes.
All right. Okay, there's so many, let me say millions of Kenyans who are watching us this morning, and wanaangaliana hivi the partners, and they're like, whatever these guys are discussing is what we're going through. And you had alluded to this earlier, the Supreme Court decision last year, and a quote of it says, as courts should shy away from imposing marriage on unwilling persons, yes, so for that bit, shy away from imposing from unwilling persons.
Yes.
Is there any circumstance where the courts will take a look at a case of a couple that has been cohabiting and say, well, for you guys, this was actually marriage? What kind of proof should be put on this table to say this was actually, yes, I mean, but there you guys were married?
The most important, in my view, is usually an intention. First, long cohabitation. So I don't think 1 year is enough to show that you guys were married.
But long here is not specified the number of years.
It's not specified. But I think reasonably, long cohabitation, stay for a long time. Maybe long enough for a child to.
So kids are a big factor here. Kids should be on the table.
If you get a child and you take the child to school, especially when the child goes all the way to grade 8, I mean, that is long cohabitation enough, in my view. If I was a judge, I would deem that enough.
Right.
Almost 10 years cohabitation, for me, that will be enough. Long cohabitation.
Okay.
That's the first factor. The second factor, you held out yourselves to the world to be married. There are sometimes you're telling the world, this is my partner. You're just telling the world, this is my partner. So you are clearly telling the world, this is not my wife, or this is not my husband. You're telling the world, this is my partner.
So choice of words here.
It's important, sure.
So ukipost tu mtu wako hapo nyumbani, be very careful on the choice of words there.
Exactly. So hold out to the world that this is my husband, this is my wife.
Okay.
And you send them, when you send someone, speak to my wife, so there's the holding out to the world that you're married. Then the other one is an intention to marry. There are instances that you find a couple wanted to marry, maybe for financial constraints, they couldn't marry. And maybe what they did first, they did an introduction without the rituals, just an introduction, and said, now we will come officially to bring the bride price. But the young man, due to many economic factors, maybe he lost the job, could not now bring dowry, and they get a child. Now the money is focused on bringing up the child and not complying with these customary rituals.
Yeah.
That intention, you can see there is an intention on both parties to contract a marriage, but for other circumstances they could not. So those three, in my view, but importantly, actually, what the Supreme Court held, capacity. So that if you're living with someone else's husband, especially if the husband is married under civil law or Christian marriage, that husband has no capacity to contract a marriage with you.
Because someone else's person there.
Yes. So no matter if there was long cohabitation, there was an intention to marry, you held out to the world that you're married, doesn't matter.
Okay.
That is someone else's husband or wife. So he has no capacity to contract a marriage with you.
Let's pick this call from Lucy from Kamulu. Lucy, habari asubuhi. Hello Lucy.
Hello, nakusikia.
Lucy, kama uko na sisi tafadhali paza sauti, and I hope umezima.
Nimezima.
Thank you very much. Ukoaje hii asubuhi? How is Kamulu?
It is okay.
Uko na swali for wakili ama ni maoni?
Ni swali.
Yes, uliza tafadhali.
What happens when you are a mistress for like 17 years?
Okay.
And you have a kid.
All right.
And this man is known to your family, but hajafanya dowry, and you're also known to his family.
Okay.
And he's married.
All right.
So they have property.
All right.
But the property, if you look at the business name, it is written both husband and wife. But the land on which the property stands on is written on the man's name. My question is, where do my kids fall on that issue of inheritance if the man unfortunately passes on?
All right. Lucy, before Kate, how many children in this case?
One
child. Okay. So thank you very much, Lucy. Salimia sana watu wa Kamulu.
Okay.
Yes, 0795-045-864 is the number to call us. Kama Lucy, unaweza uliza swali yako for Wakili, and be sure that he'll be answering them as we continue. Wakili, a very interesting question here. It's not a familiar case. The country, you've seen it. How does Lucy engage this?
So 17 years is a long time.
Yeah.
That, in my view, definitely is long cohabitation. I think, let's be clear, introduction to parents alone is not necessarily an intention to marry. In fact, one would argue on the flip side and say, if you are introduced to the parents, what stopped you from getting married? I mean, what stopped you from doing the traditional ceremony? That's the other side of the coin, which someone could use to argue that, in fact, it shows you didn't want to get married. You are happy people knowing that you're living together, but the two of you didn't want to get married. So, as I've said, courts will interpret it differently, and it depends. So I think for me, it's, have you held out to the people, to the outside world, that you're married, and also have you communicated this intention to others?
All right.
I think introduction itself is not, but if during the introduction you had maybe intimated that we're planning to get married next year or in 2 years, that could hold water. However, still, we're going back to the court saying that a presumption of marriage is to be applied sparingly. So upon death, what happens? Upon death, I think the child, definitely, if the child will inherit.
All right.
About the wife being treated as a wife, I'm not sure.
Okay. Yes. And just to break it down, even for, in case you're watching us, so for 17 years, the mistress was the one kid. She's known to the family. There's property that is there, but it belongs to the husband and wife, but the property is under the man's name. So can the child now inherit, as you're continuing to explain? But then now another twist to this, which can also continue to elaborate for us. The man now becomes the deceased. Now for the wife, can she stop any inheritance proceedings to continue now for the mistress? And even as you also think on that, we do have Bernard from Nairobi. Bernard, habari asubuhi.
Habari yako?
Mimi niko salama. Umekunywa chai? Changamka kidogo Bernard bana.
Nimekunywa chai tayari. Swali la asubuhi ya leo ni kwamba ikiwa mtoto kuna mtoto alikuwa shule akapashwa mimba akiwa bado shule, alafu huyu msichana bado hajaolewa hadi wa sasa, mtoto alifika kama miaka 18.
Okay.
Sasa hivi anahitaji kuangaliwa na anahitaji kama hela za kumpeleka shule na kadhalika. Sasa huyu mume ambaye alimpasha huyu msichana mimba, sasa hivi ako na mali. Kuna vile tunaweza kufuatilia aweze kusaidia huyu mtoto.
Okay. Ndio tukuelewe vizuri, huyu umesema 18 years, ako 18 years sahi ama ni 18 years ago?
Sasa hivi mtoto ako na 18 years.
Ako na 18 years, okay.
Amefanya form 4 lakini hela za kwenda college zimekosekana. Sasa ndio nauliza wakili kama kuna vile tunaweza ongea na huyu mtu kupitia kwa sheria ili aweze kumpeleka shule.
Okay.
Na kama kuna uwezekano aweze kuinherit mali pale.
Right. So wakili amepata swali yako. Thank you very much, Ben. Salimia sana watu wa Nairobi. Yes, wakili, I think we can start with this one before we go back to Lucy's question. You've captured the question?
Yes, I think from what I've understood is that there's a child who's 18 years old.
Yes, and she got a child when she was underage. And now the gentleman wants to know, Ben wants to know if they could have the father of this child to, first of all, take the girl, in this case, to school, to college.
Yes.
And also if she and the child can inherit the property.
Yes, I would advise that they move to court as soon as possible. Because under the Children's Act, currently, the role of maintaining a child extends even after they turn 18 to especially taking them to college, to the first years when someone is deemed to be in college or in university, in tertiary education. Okay. So if they can move to court as soon as possible, the better, to avoid the overstaying. However, the maintenance should only be limited to her education and the needs that surround her education, because she's in essence an adult.
Right.
Yes, there are cases where the court have said, no, you're an adult, you don't have to be maintained. Can she inherit? Yes, she can inherit because that is her father.
Okay.
As I've said, a child can inherit from the parent, and it doesn't matter if the mother is not married to the parent. The child will inherit.
Right.
Yes.
Now, getting back to Lucy's question, you briefly talked about how for the child, and in context again, Lucy says there's a mistress, and for 17 years there's a kid known to the family. There's property belonging to the husband and wife, but the property is under the husband's name. So, and we've seen this a number of times, where there's a will that was written, but then the mistress was not included in this will. The wife was included, but the mistress comes later and says, hey, ngojea, mimi nafaa kuwa kwa hii will pia, I should also inherit some of this property that is here. And the wife would want to stop that from happening. How does that go about?
Yes, under the Kenyan law, section 2(5) of the Law of Succession Act, the mistress would be entitled to actually inherit herself if she was actually a wife through customary law. Because despite the fact that maybe the husband contracted a civil or Christian marriage, meaning that he could not contract another marriage, for purposes of the Marriage Act, she is not a wife. But for purposes of succession, she is actually a wife. That's the interesting part of the law. And so the mistress, that's why the mistress actually go to stop any inheritance, because she's a wife. But in all other instances where especially there was no tradition or ceremony, it's only her child who can inherit. If the child belongs to the deceased, only the child can inherit the property. So can someone go to court to stop? Yes, someone can actually go to court. Even a will can be reopened and reasonable provision made for a dependent. A dependent meaning a child of the deceased, a wife of the deceased, in fact, a former wife of the deceased. I don't see, though there are factors that the court will consider. Did the deceased give you anything when he was alive? Did you used to depend on him? So there are other factors that the court will consider. It's not that it's automatic when you go to court to stop, that the court will just listen to you and agree to stop. Yes, I think Lucy's concern was the property is registered in the man's name.
Yes.
What I don't know if the man has another family, but if the man has no other family, I think Lucy can argue about the existence of a presumption of marriage, especially if she was the only one arising out of long cohabitation. I think that she has a ground there for claiming marriage, but also seek provision for the child.
Let's pick this call from Grace kutoka Karatina. Grace, habari asubuhi. Yes, hata sisi tuko hapa salama. Nitaomba upaze sauti kidogo. Sijui uko na swali for wakili?
Ya, niko na swali yake. Na swali yangu iko hapa.
Okay.
Mimi mmeeleza naelewa kabisa, niko kwa Kamwiste.
Okay.
Niko na mtoto mmoja. Bwanangu ameajiliwa.
Okay.
Ikikuja sasa kwa next of kin yake, ameandika babake. Kwa beneficiaries anaandika mtoto wake, alafu kwa spouse ananiandika mimi, but sina any document.
Hakuna any documents?
Yeah, but
okay.
Ikikuja kwa spouse ananiandika, kwa dependents wake anaandika mtoto wake, hapo juu sasa anaandikanga next of kin kama babake.
Okay.
What happens for situation kama hii?
Alright. So sawa, wakili amepata swali yako, atakuwa na kujibu sahihi. Thank you for your question, Grace. So sawa.
I like that question because it answers this thing of holding yourself out to the world to be married. Because if in a form that requires you to fill in spouse, if you wrote I'm single in a form, maybe a legal document required by a bank or a school, you wrote married or single, you write married. You write married. Who's your spouse? You write the name. It means you're holding out to the world that you're married, and maybe there's also an intention that you intend to be married one day. So in that case, even next of kin, you keep including her. I think that is a good example of a situation where a presumption of marriage would arise.
Right.
Yes.
So for Grace Ako, they're in the right path on that one.
Yes, they're in the right, but as I've said, different judges will look at it differently. Myself, I am for the view. I usually advise people. It's very affordable to contract a marriage at the AG chambers. Go for it. If you don't want a civil wedding, do a customary wedding, because this presumption it can go either way. It can go either way. Some judges, you see, if all judges are influenced by their leaning. So maybe some judges are lean towards protecting the institution of marriage, and they feel like the institution of marriage should be held with high regard. So if people are not married formally, why should we give them the status of marriage? So others will be easy and relax the rules and say if they held out to others as married, they stayed for so long, they intended to get married at some point, let's give them the benefit of doubt and presume that they were married.
Right.
So why take the gamble?
Right.
Contract a marriage.
Wakili, the people who really want to know the process of writing the whole will, so I think we can start with that because in last year's ruling as well, the judges told the National Assembly as well as the Senate and the Attorney General to have a state law that deals with cohabitees in long-term relationships. So even before we get to that, there are many people watching this morning and they really want to know. Nimeishi na mtu for this long and we've amassed property. How can we, write the whole inheritance? I think one of those people is Lucy. Lucy's back. Hi, Lucy. Thank you for calling us back. Uko na clarification ama ni maswali mengine?
Ni clarification.
Okay.
Now, Lucy is the mistress.
Okay.
With one kid.
Okay.
The man has a family. Now, their properties, it is, they have a business name that is registered under both of them. But the main properties, those same properties, the title deeds are under the man's name alone. So that is where my question is coming from. Can my children inherit if the business name is written as joint but the title deed is under the man's name.
Okay.
I'm the mistress.
All right. And Lucy, allow me to ask you this because there's something wakili alikuwa amesema ile for the partner anasaidia kuamasi i wealth na property. On your end was there that ile kusaidia kutafuta i property in whatever means?
Not really, but there are times anakuitisha like 50,000 unampea 100,000. Like there is a business we had and it was mine. We sold it, and since we have a joint account,
Okay.
he took the money because the same project was running.
Okay. So thank you for that, Lucy. Wacha wakili atuambie sasa what he thinks.
Is, as I've said, the children, especially the children always have a right to inherit. And when you say children, don't mean necessarily people who are below the age of 18. As long as you are a child of the deceased, even if you're a grown-up, if the deceased dies, you can establish that they were your parent. Mostly it's DNA testing, or the deceased had taken you as their child. There are cases where you're not the biological child, but the deceased had actually taken you as their child, provided for you and adopted you as their child. In that case, you are always entitled to inherit. So in that case, I will tell Lucy to not worry. The children will definitely have a right. It doesn't matter in what way it is registered, as long as that property still belongs to that man. The children will be entitled to inherit. Yes. What was the other question?
No, for the other one, because that was what I was asking her. In this 17 years, was there any proof that she actually helped Thomas? And as she says, there's a time the man would ask, Sedina, 50,000 happened, Sedina, this amount of money. How does this play out in the courts when it now comes for her own inheritance? It's
difficult sometimes to prove a contribution towards acquiring the property, because most time in a marriage setup, myself being married, I will not, whichever money I give your spouse or your spouse gives you, you don't write down, that.
But there is M-Pesa balance though. Can that be used as?
Yes, M-Pesa will be used. The only problem is that after long cohabitation, maybe you may not be able to retrieve those statements from
Safaricom. Has those.
The banks and even M-Pesa, they have a time which they delete the records.
Okay.
Because the laws allows them to delete records after a certain amount of time.
Okay.
So going to retrieve 20 years ago statements may be difficult unless you used to retrieve them and keep them yourself now. Hoping maybe this will happen, or just the people are very organized.
Yeah.
Every month they get their bank statements, they file them. So unless that's the case, but giving out cash to your spouse you may not be able to prove. So sometimes, unless you have a witness who was there, but statements are good. So that will usually establish that the spouse, though the land is registered in his name, he's holding your interest in trust for you. It's a constructive trust. It's found in section 38 of the Land Registration Act.
Right.
Yes.
Ladies and gentlemen, that's a hack for you. Hizo receipts zote ziekange mahali. Because of the interest of time, I had asked you to help us understand how to go about the writing of a will. And
yes.
Particularly for a cohabiting couple, they're not married. Whatever amount of time, 1 year plus, how do they go about that?
It's good to write a will. And a will written, the good thing with a will is that when you die, courts will seek to, as much as possible, enforce your wishes. So that as long as you've not left out the main people who should have inherited, you've not left out your children and your spouse, your legal spouse. As long as you've not left them out, court will enforce what you've said. So, and you should give them reasonable provision. So if you decide that you want half of your wealth to go to a foundation that is doing a research on HIV/AIDS vaccine, court will always try to enforce your wishes. So in the case of a come we stay marriage, if you decide
where there's no legal spouse term here.
Yes, there's no legal spouse.
Yeah.
If you still decide through a will to give property to your come we stay partner or to your partner, if you may use that word, court will enforce it.
Okay.
Yes. It will only be challenged by people who are now by law entitled to inherit from you, maybe your children, if they feel like you've left so much to your come we stay partner to their detriment. That's when the law allows an opening under Section 26 about a reasonable provision for dependents. Now that's the problem. That section made a will sometimes to be of little value if people can still challenge your will and say that I feel like what I've been given is too little. So if your children feel like what they've been given is too little, they may challenge it. Though I doubt most of the time that children will go to challenge wills given to their parents because they still inherit from that partner if they are biological children of that partner.
Okay.
So a partner can inherit from a will.
When you're drafting this will,
Yes.
Because now this is not a legal spouse.
Yes.
Are there any differences from this kind of a will to the other will that a married couple will have?
So a will, there are formalities of a will. To take you quickly, I hope people are noting down. Yes. So for a will to be valid, it must be signed by the person who is signing the will, called the testator. Then there must be two witnesses who attest, who say that we saw this guy sign the will. And these two people who are attesting should not be benefiting from the will. So if you choose to write a will today and you're giving property to your partner who's not your spouse, even if it was your spouse, even if it is your children, that child cannot be the person attesting to it. Yes. And if they are, then there should be another set of two people attesting again. So to avoid that, the beneficiaries in a will should not be the ones attesting. That's the second situation. So that's the formalities. However, there are situations where wills are suspicious. So you don't take a will to to someone when they are on their deathbed. The partner now comes with a will. Please just sign. So avoid suspicious situations. I will advise if you don't want to be formally married to someone, but you want them to inherit your property, this is what I will advise. I will advise sign the will when you're healthy.
Okay.
Yes, don't have them attest to it. Have some independent person attest to it if you want to use the will way. The other way is register property jointly with them. So that, and when I say jointly, it's called joint ownership. So that when you die, the property automatically devolves to them. So register property jointly. Or also it can be tenants in common, where when you register the property, you say 50-50 or this percent.
Do you need to include those two, the joint ownership as well as the other one you've mentioned right now?
Tenants in common.
Tenants in common in the will. Do you need to include them?
No, not in the will. I'm saying now apart from
now the will. Okay.
Apart from the will idea, if you want your spouse, your partner to get something to be protected, or if you are a partner and you feel like you want to protect your interest, always ensure that property is registered jointly.
All right.
Yes.
Wakili, as a legal practitioner,
if you acquire it together, yes.
Right. Wakili, as a legal practitioner, what do you think about this ruling by the Supreme Court last year, January, specifically where the judges were telling the National Assembly, the Senate, the Attorney General to come up with a state law that really deals with cohabitees in long-term relationships and really outline their rights and their obligations clearly. If you're having a public participation with your legal experience,
yes,
what kind of insight will you be providing in this case?
For me, one, I would urge Parliament to give us a definite term After what time do we deem people to be to have cohabited for long enough for a presumption of marriage to arise? 2, do we call them spouses or do we just call them partners? So that if we call them spouses, then we're just amending the Marriage Act. So there's no need for that. So we just call them partners. If they're just partners again, do they have right to inherit the same way a wife would have a right to inherit? So that if we are coming up with that law, are we also amending the Law of Succession Act to allow for a long-term cohabitee who is defined by law? What is long-term cohabitation?
Right.
And then lastly, if, there are instances where death has not yet happened.
Yeah.
Like this Supreme Court case, these were people who were still alive but had lived together for long.
For a very long time.
And one was aging out the other in a property. So before death occurs, how do we deal with their property? Do we assume, like in the case of Marriage Act where people are still alive, it's called Matrimonial Property Act. So division of matrimonial property is well provided for. It's usually after divorce. So in this case, I will also say, is it after, what is the equivalent of divorce in a come we stay? Is definitely will be separation. Deciding, let's live apart again, let's stop this relationship. So at that point, is it that point that the property they bought together is going to be divided? And if it's going to be divided, what is the share?
I hope the National Assembly, Senate, Attorney General are writing this, because these are very pertinent advices. Also what people are saying on what we had asked, just very briefly. So Peter Mwadime says, hell no, get what you brought. Peter M says the better option is just to get married. If you two love each other, decide on settling in and have a legal marriage certificate. From there, you can confidently decide on your fortune. We're asking you, in your view, do you think partners in a come-we-stay relationship should grant each other inheritance? That conversation continues on our digital platforms. Endeleni kutuongelesha pale, tutafurahia sana. This has been the whole conversation on Matters Law. Taking a short break, then when we come back,